happy Friday. Check your calendar. It is Friday, right? Bishop on air. We've got tons to get to, as always, with stuff just popping off all week this week when it comes to litigation against the state's gun and magazine ban. But we're expecting the weeks ahead to be pretty busy as well. So if you want that day-to-day play-by-play right here, you'll find it with Bishop on air. Be sure to like, subscribe, and follow along. Anywhere, really. I think Twitter's a good place to get the instant stuff if you really want to know what's going on, so follow me there. X, formerly known as Twitter, and you can also click the notification there. But we're live each and every weekday morning around this time here on major social media channels. YouTube, if you're following along, switch that little notification bell, all right? And check out the shop below. Get yourself a Bishop on Air mug, a bunch of different designs for hoodies and women's t-shirts and hats as well. My wife Megan splurged and bought a whole bunch of it herself, so good gifts to give out. All right, coming up today, we've got the conversation about what happened with the U.S. Supreme Court and what it means for Illinois' gun and magazine ban with Amy Coney Barrett, essentially telling the state that they have until December 6th to respond to the Naperville plaintiffs. So we'll actually connect with Hannah Hill and Robert Beavis from the Naperville case, the plaintiffs in that case, about what's going on. So that's coming up just in about 15 minutes. But we've also got to talk about some things that have been happening at the Illinois Supreme Court, including some headlines out of the Illinois Attorney General's office, the Illinois State Police, and more. Stay tuned. We've got a ton to get to on this Friday morning. Like, subscribe, follow along. Appreciate you guys tuning in and supporting the program. All right, so let's make it happen. All right. So the Illinois Supreme Court, they gave a ruling yesterday concerning the Illinois Firearm Owner ID card and the Freedom of Information Act. Here's the headline. Illinois Supreme Court rules FOIA of FOID information not allowed. This happened yesterday, shortly after we got done with our broadcast. And if you recall, we did talk about this case when it was heard back in September. And that's, of course, Supreme Court Chief Justice Mary Jane Teese during Supreme Court oral arguments. And this case really, it stemmed around the idea of should you as an individual who is looking to get information about your FOID card being suspended or revoked, should you be able to get that information about yourself via the Freedom of Information Act, right? The Freedom of Information Act is a law that requires government bodies paid for by you, the taxpayer, to turn over public records. Now, there are some exemptions that are carved out in law, and each state really does have the ability to kind of craft their own law when it comes to what you can access via public records. For instance, I put a lot of public records requests in myself, could always do more. But there's a fine art there. You have to know kind of specifically what you're looking for, but cast a general enough net to be able to get stuff you might not know you were looking for. So there's a certain art and a craft to FOIA. But when it comes to you looking for information on yourself, you would think you should be able to have that ability. Well, this case came in front of the Illinois Supreme Court and involved two individuals who were looking to file Freedom of Information Act requests, or who had filed Freedom of Information Act requests with Illinois State Police to get access to their personal individual information. There's some interesting debates that could be had about this. Should they have known that if it's released by FOIA, it's publicly available to anybody? And I don't know if people understand that part about FOIA. There are some governmental bodies that have running lists of FOIA requests and the responses to those requests. And anybody can open that page up and find those links. Not every governmental body does that. Those that do, it's pretty fascinating because you can spend all day and find all kinds of pretty incredible information. But regardless, FOIA requests are FOIA-able. So if you as an individual are looking to get that information through the Freedom of Information Act and it's approved and they release that individual information about yourself, then that could possibly be accessible through another Freedom of Information Act request. So there's some interesting kind of loopholes that you want to make sure are closed, especially when it comes to your own personal information. So let's flash back just to some of the arguments from when this was heard by the Illinois Supreme Court back in September with two individuals trying to get information about why their FOID card was either denied or revoked. And when you are in Illinois, you have to have a firearm owner identification card in order to exercise your Second Amendment right to keep and bear arms. It's challenged in the courts in both the federal and state level on the constitutionality of it, but this is a different case. This deals with whether or not you can have access to the rationale behind why you were denied or had a card delayed. Interesting arguments, but you had a couple of people who were wanting to get their personal information, so maybe they could better appeal to get their FOID card in place. And this is kind of how some of those arguments played out with the attorney representing the state laying out why they think that the plaintiffs suing the state because they couldn't access their Freedom of Information Act requests FOID information. So here's the state defending what they say is the importance of keeping private information private.
And it is clear that the General Assembly did not intend to include an exception in. And it is clear that the General Assembly did not intend to include an exception of any kind in that prohibition, because not only in the same provision, but in the very same sentence, the General Assembly explicitly allowed for an exception for information of applicants for a concealed carry license. Under the basic principles of statutory construction, that omission has meaning. And that clear, unequivocal language should have been the end of the inquiry. The inquiry should have ended not only because the provision's language is so exceptionally clear, but because, as ISP pointed out during the circuit court hearing in Mr. Burgess's case, that the way to get a copy of your application or denial letter is not by making a FOIA demand of ISP's FOIA officer, but to contact the Firearms Services Bureau directly. No one is trying to keep people's personal applications or denial letters a secret from them. But the Firearms Services Bureau needs to be able to verify that you are who you say you are before releasing copies of your confidential information.
So ultimately,
the
the argument
people to provide proof of
the
identity.
argument is that there are different avenues to go. So these were arguments made back in September, right? Whenever the Illinois Supreme Court heard this case of individuals trying to get their personal private information through the Freedom of Information Act. Maybe they felt that they just weren't getting the information in a timely manner. They wanted to appeal to this new board that's created for FOID appeals, and they want to get that process because they have a right to keep and bear arms, but they feel that their rights being withheld inappropriately. And that could be some of the sentiment behind wanting to get your records as soon as possible within that 5 to 10 day window that the Freedom of Information Act requires. So some of the questions that were brought up to Thomas Mag, who is the attorney for one of the plaintiffs in this group here in front of the Illinois Supreme Court back in September, dealt with that idea of different channels to be able to go through to get private information about your FOID application instead of going through the Freedom of Information Act request. Here is Supreme Court Justice Joy Cunningham asking Mag about that very question.
Response to the assertion that FOIA was the incorrect vehicle for seeking this information and that there was another appropriate vehicle that is in place for the parties to get this information without using FOIA.
It's obvious that counsel has never tried to get any documents out of the State Police Firearms Services Bureau. In some, they don't answer the telephone for hours at a time. they don't answer emails for days and/or weeks at a time. I mean, I invite this court to go to their website and dial the telephone number and see how many hours it takes to get a person, if you even can.
Obviously, all of this is way beyond the record here.
That was what my next point was going to be.
That's Chief Justice Mary Ann Teese.
Talking about things that are out
Mary Jane Teese.
of the record. But if asked, I'm doing my best to answer the court's questions.
So, can you respond to the argument that Section 2, C5 specifically controls here, that identifies what private information is, and so therefore that is the kind of information that is not discoverable under the Freedom of Information Act?
Okay. What is private information is not, well, it may well include names, addresses, that type of thing. But that's not what we're seeking here. Quite frankly, we don't care if the state redacts my own client's names from my own client's record. That's not what we're trying to get here. What we're trying to get here is, counsel made reference to government action. We're trying to get to what the government's stated reason was for revoking, suspending, otherwise invalidating my client's FOID cards.
So again, that's the chief argument here. His clients are looking to get that information from Illinois State Police, and they apparently couldn't get it in a timely fashion as a way to try to challenge a suspension or a revocation or denial or whatever the case may be. It's not trying to get that personal information about their home address. It's trying to find out what the government action is. And that's really what the Freedom of Information Act is built to do, is to build to show you what the government action is. But the Chief Justice of the Illinois Supreme Court, Mary Jane Teese, she had another question that Attorney Thomas Magg had to respond to.
And we're debating what these words mean, where it specifically there are certain documents that cannot be inspected and copied under FOIA. Another piece of it, of the same statutes, has an exception that can be, where information can be revealed, and that's under the databases under the Firearms Concealed Carry Act, records of the Concealed Carry Act Licensing Review Board under the Firearm Concealed Carry Act, and law enforcement agency objections under the Firearm Concealed Carry Act. So you say that that doesn't work very well, but that's not what we're talking about. We're saying this is what the language says.
Well, if you want,
this is not, these documents are not subject to FOIA, can't be inspected or copied, but there are other avenues where people can get information.
well, if you want to get ultra technical, the unless otherwise authorized by the Firearm Concealed Carry Act. If you go to the Firearm Concealed Carry Act, it expressly authorizes the release of denials and revocations of concealed carry licenses, which are, at least at this point, printed on FOID cards. So if you want to get ultra technical, that's an authorization under the Firearm Concealed Carry Act. But I don't think you get that far, because we're not seeking information of people, we're seeking information of why the state acted for the persons who they acted against.
So ultimately, those are the arguments that were made back in September. The Illinois Supreme Court, regardless of it having a composition of more Democrats than Republicans, were unanimous in denying somebody being able to go get their FOID denial information on themselves through the Freedom of Information Act, even if they consent to disclosing that information. The Illinois Supreme Court released that ruling yesterday. So fascinating stuff. Another story also that they released was the case was about the Biometric Information Privacy Act. If you're not familiar with this, BIPA, it of course was a measure that was passed years ago and is supposed to protect workers or individuals from having their face scanned without their permission, or their fingerprint used without their permission. You've seen the Facebook settlements, and even White Castle's facing a daunting settlement, possibly after workers successfully sued that burger joint for requiring fingerprints for the workplace. So regardless of where you stand on the issue, it's been very contentious in the courts, and healthcare workers were suing hospital systems for requiring that they use their fingerprint to access cabinets with secured, scheduled drugs. and they sued using BIPA in state courts, got all the way up to the Illinois Supreme Court. They argued that their rights are being violated, but the hospital systems say that, well, it's all protected under the Health Insurance Portability and Accountability Act. I think it is HIPAA. But regardless, Supreme Court yesterday released a unanimous ruling saying that the hospitals are in the clear because that information is protected by HIPAA. So BIPA can't supersede HIPAA. Another Illinois Supreme Court case that we wanted to follow up on with you. All right, so those are just some of the things happening there. We've got tons more to get to, guys, from the Illinois Supreme Court all the way to the U.S. Supreme Court. We had this news come out yesterday, and we're going to get even more from this. And pretty exciting stuff for those of you who've been following the gun and magazine ban all this time, and all of the different ins and outs that we've had to watch happen throughout. But here is Dudley Brown from the National Firearms Group that is helping sue the state and city of Naperville. Here's his announcement from yesterday.
Breaking news, we just got word that Supreme Court Justice Amy Coney Barrett asked the state of Illinois for response on our emergency appeal on the Illinois assault weapons ban. That means it's quite possible that the Supreme Court could intervene in that case and demand that they accept Bruen. That's what we're hoping for. We hope you're praying and crossing your fingers.
So we'll talk with Hannah Hill, and also Robert Beavis will be on the line as well, with the National Association for Gun Rights and Law Weapons taking their case again to the U.S. Supreme Court. So that conversation's next here, all right? Appreciate everybody tuning in. It is Bishop on Air. Follow me anywhere. Just search Bishop on Air, and you can connect with me on X, Facebook, and YouTube, and we can ask me questions there. You can find the shop at bishoponair.com. So make it happen. We'll see you here back in just 2 minutes, all right? I got to get them hooked up. Got to get them on the line, so stay tuned.
All right, Robert, can you hear me?
I
can, Greg. How are you?
All right, good. We're standing by, waiting for Hannah to join, and we will be live. We're actually live right now, so everybody can hear you, but
Okay, great.
stand by.
All right. Hannah should be in any minute.
And here she comes. All right, we'll get this loaded up. And live internet broadcasting, just to give you guys a heads up, we are live. Hannah, thanks for taking time. Give me that thumbs up that you can see me, or at least hear me. I think, can you hear me, Hannah? Coming in, Hannah. Looks like she's working on it. Stand by, audience. All right, she's checking on something. Stand by.
Let's switch over to some earbuds there. Another microphone. How are things going, Greg, with you?
So far, so good.
Great. Glad to hear it.
Enjoying doing the live show. And by the way, as we get ready to talk with Hannah and Robert, just a heads up, I was doing terrestrial radio for years, decided to come home, do this home studio thing, and you guys are showing your support by checking this out every day, and I greatly appreciate that. I will be filling back in on WMAY on Monday, Tuesday, and Wednesday next week. So that's going to be fun to kind of step back into the traditional terrestrial radio show, but obviously a lot of other things going on in my full-time gig, so glad I'm able to wake up each morning and do this with you. Hannah, can you hear us? Thumbs up?
I can hear you.
Fantastic. All right, well, let's go ahead and get this going then. So let me just get everything set up here so we are ready. But obviously, there's been some big developments when it comes to the case that Robert has against the state of Illinois. So let's jump right on in. With Bishop on Air, we've been tracking the ongoing litigation against Illinois' gun and magazine ban. Of course, background, January 10th, you had the law that was enacted statewide, banned more than 170 different semi-automatic rifles, shotguns, handguns, magazines over certain capacities. It also had a registry component where the deadline for that is coming up in 30 days. So at the end of December 31st into January 1st, if you don't register a semi-automatic firearm or a banned attachment or 50 caliber categories, then you could find yourself being turned into a felon overnight. Obviously, this has been sued on state level, on federal level. You've got cases from the Southern District and the Northern District courts that were consolidated into the Seventh Circuit Court of Appeals. Seventh Circuit Court of Appeals has sided with the state, saying they have a likelihood of success. But one case really kind of came before all of the cases against the state's case, and that is the case out of Naperville. And why that is because, well, Naperville had a ban well before the state did, months before the state did. So now we've got some news that broke yesterday with the U.S. Supreme Court Justice Amy Coney Barrett telling the states that they now have till December 6th to respond to the states, to the motion from Law Weapons, Robert Beavis out of Naperville, and the National Association for Gun Rights, looking to have an injunction on this case. So joining us is, of course, Robert Beavis and Hannah Hill from the National Association for Gun Rights. And Hannah, we talked about this before, but I guess if you could just kind of, what makes this request to Amy Coney Barrett different than the previous request when you guys brought it before the Seventh Circuit actually took the case and had those oral arguments?
Right. Well, that's a very good question. And the simple answer is this. The first time we asked for that emergency relief from the Supreme Court, the Seventh Circuit had not ruled. And the Supreme Court's position for Second Amendment cases ever since Bruin has generally been to take a hands-off approach until the lower court process is finished. Now, in our view, it was worth a shot because a right delayed is a right denied. Naperville and now Illinois are denying the gun rights of law-abiding Illinoisans and literally putting Robert out of business. And so it was worth a shot. And we had hoped that the Supreme Court would see it that way. They did not, but only after the Seventh Circuit saw that the Supreme Court was looking at the case and then said, all right, tell you what, we'll expedite our side of it. So they put us on what our lawyer calls the rocket docket. And we got our oral arguments on that case much sooner than we normally would for an appellate level case. We just got that ruling back not long earlier this it's December now. We got it back at the beginning of November. And it was one of the worst rulings we've ever seen. They literally ruled that America's rifle, the AR-15, is not a gun as far as the Second Amendment is concerned. And it should tell you what kind of arguments we're dealing with. If that's the kind of argument they had to resort to in order to make any sort of a case that, they can uphold the Illinois assault weapons ban. So to answer your question, the difference is that now we've got a ruling from the Seventh Circuit. We have asked for the entire review of all 14 judges on the Seventh Circuit, but that's an extra step. They aren't required to grant it to us. We are not entitled to that hearing. And so the fact that we have in hand a Seventh Circuit ruling that is outright defiant of not just one, but two Supreme Court precedents on the Second Amendment, we think is a very compelling case for the Supreme Court.
So if you could talk a bit about, I guess, what's the precedent that you guys are looking for the U.S. Supreme Court to, I guess, double down on against what the Seventh Circuit did. What are some of the major issues in that precedent for people who may not have been tracking this the entire time or even know about what Bruin is or what Heller is? Talk about, I guess, again, what you guys are looking for the U.S. Supreme Court to double down on and have that preliminary injunction while the discussion continues all the way back up to the U.S. Supreme Court.
Right. Well, there are two of them. One is the 2008 case, Heller, DC versus Heller. In that case, the Supreme Court basically said that you have a right to have firearms in your home, basically doubling down on the right to possess firearms, right? They said things like, basically, you cannot outright ban firearms that are in common use. They said that all bearable arms are protected by the Second Amendment. So that alone should make this case a slam dunk. But then last year, they gave us the Bruin case. That was a challenge to New York's de facto ban on public carry. They had left it so discretionary for public officials to deny permits to carry firearms that it was almost impossible to get one. And self-defense wasn't a good enough reason in the eyes of the law to grant you that special permission to carry a gun. So with that case, the Supreme Court said, not only do you have a right to possess arms, as we said in Heller under the Second Amendment, but the Second Amendment protects your right to bear arms as well. But we're going to take it a step further. They also struck down what's called interest balancing. So the lower courts had invented what they called a two-part test every time they got a gun case before them. They would essentially run a cost-benefit analysis on the Second Amendment. They would say, okay, well, what is the public interest of this gun control law? And then they would balance that against the Bill of Rights guarantee. And almost every time, gun rights got the short end of the stick because it was never about the facts at all. It was always about, let's find a way we can get around the Second Amendment. We can circumvent that and say, it's a good idea to have gun rights, but we think it's just too dangerous because we don't like it. We are not comfortable with the idea of law-abiding citizens having guns for self-defense. So the Supreme Court in Bruin said you cannot do that. Now, the nice thing, I say the nice thing that makes our argument so easy to the Supreme Court right now is that in the Seventh Circuit ruling that we're appealing, they violated all three. They violated Heller when they said that AR-15s are not guns. They violated Heller when they said that a weapon that is owned by tens of millions of Americans, and that's a conservative estimate, is not in common use. And then they violated Bruin when they resorted again to that interest balancing test, and they took it a step further and said, we don't think the Supreme Court actually struck down interest balancing. And it could not have been more clear that that's exactly what the Supreme Court did do in Bruin. So this is a very, very defiant ruling. And all we're asking the Supreme Court is to confirm that they meant what they said in both Heller and Bruin.
We're talking with Hannah Hill. She is with the National Association for Gun Rights with a case up at the U.S. Supreme Court asking for the Supreme Court to intervene. So, Hannah, if you could give us kind of what some of the outcomes could be, right? I mean, December 6th, the state has to respond. But since the Seventh Circuit has already acted, could there be a preliminary injunction put on the law while the case gets up into the U.S. Supreme Court and there's oral arguments and a decision down the line? Or could they just not do anything and then the January 1st deadline kicks in, but the court case still continues? What are some of the outcomes there, if you could spell that out for us?
Right. So basically, what you just said there. So what we're asking for is an injunction. An injunction would block the enforcement of both the Naperville ordinance that's preventing Robert from selling his guns, and for of the state law that's preventing Illinoisans from possessing these after the new year, unless they've registered them. So we're asking for that injunction to suspend these laws, prevent them from being enforced throughout the en banc review, as it's called, if we get the full 14 judge review from the Seventh Circuit, and any subsequent petitions to the Supreme Court. So we've kind of signaled to the Supreme Court that if we lose at en banc review, or if they don't give it to us, we're appealing the full case on the merits up to the Supreme Court. And we would like this injunction to apply throughout that whole process. So basically, we're asking the Supreme Court to suspend the enforcement of that law until the case is decided. Now, for an emergency appeal like this, they go first to the Supreme Court justice that's assigned to that particular circuit. In the case of the Seventh Circuit, that's Amy Coney Barrett. And she has the authority to grant this injunction all on her own. She could do it. She could also forward it to the entire court and have all the justices take a look at it and weigh in on it and decide as a group. Or she could just reject it. Now, the fact that she hasn't said no already gets us much further than most emergency appeals get. The fact that she's asked for a briefing, that she's turned to Illinois and Naperville and said, now give me your best arguments for why we should not grant this relief. That's hugely encouraging, but it's not a guarantee that they will say yes. So she could grant that injunction, or the whole court could grant the injunction, or they could say no. They could also say no conditionally, which they have done before in other Second Amendment cases. We're going to say no as long as the en banc court decides whether or not to give review by such and such a date. And if it takes too long, we're going to encourage an AGR and Robert Beavis to come back to us fairly quickly. More or less, they've kind of done that sort of thing before, so that's a possibility as well. If they say no, then we will fight out round 2 in front of the Seventh Circuit, and if we lose there, we will be back before the Supreme Court on the merits.
Hannah, of course, this is just an Illinois case, right? And it's just one gun store out of Naperville. You've got the cases down in the Southern District. I don't know how closely you've been following that, but you've got the federal firearms licensees of Illinois trying to block the January 1st deadline with a judge that's already granted a preliminary injunction. We've got challenges of the Illinois firearm owner's identification card pending in state and federal court. This is just Illinois. Where else throughout the country are these hot spots flaring up? And what are some of the, I guess, common themes that there are where we have gun control measures arguably infringing upon the Second Amendment right to keep and bear arms?
Well, one of the big themes is assault weapons bans. And in fact, that's our primary focus. And this case is one of 7 that we have filed across the country against both standard capacity magazine bans and so-called assault weapons bans. And the reason is because we think that particular law, that particular measure of gun control, hits pretty close to the core of what the Second Amendment's all about. But then you also have 3-day waiting periods. You have 18 to 20 gun bans. You also have so-called Bruin response bills where after Bruin struck down, said, okay, you can't leave it up to the discretion of a public official to say, do you have a good enough reason to want to carry a gun? Some states kind of doubled down on that with good moral character requirements. So in whose opinion, right? That's also a discretionary scheme. That's also in direct defiance of Bruin. New York did that, and that's currently being litigated. You also have more gun control laws than you can shake a stick at, as my dad would say, being litigated in California. Those in particular, 2 of the most prominent ones there are their challenges to the assault weapons ban and the magazine ban. Those were actually at the Supreme Court when Bruin was. And after they handed down Bruin, they kicked those 2 cases back to California, back to the Ninth Circuit, and said, now you got these wrong. Go back and read what we said in Bruin and try again. And then they kicked the can further. They sent it back down to the district court level. We just got those rulings. I say we, the gun rights community, just got those rulings, and those are very positive, as we expected for that particular judge. Those are going back to the Ninth Circuit and will probably be delayed because the Ninth Circuit has shown no sign of wanting to actually comply with Bruin. We also have another major assault weapons ban case that our entire community has been watching out of Maryland. Um, we are simply waiting for the Fourth Circuit there to hand down their panel decision on Maryland's assault weapons ban. And then the plaintiffs there will have the choice of whether or not to ask for en banc review, as we did, or appeal it straight to the Supreme Court. So Illinois' case and Maryland's case are the two assault weapons ban cases that are basically furthest along in the process. They're only one step away from the Supreme Court on the merits. In our case, we're already asking for Supreme Court review on an emergency basis. So it's not going to be long before this issue lands on the desk of the justices, and they will have to deal with it one way or another.
No question. Hannah Hill, National Association for Gun Rights, greatly appreciate your time. And I know Robert Beavis from Law Weapons hanging out there in the back. Just briefly, Robert, how important and significant is this to you as somebody in the industry exercising your Second Amendment that this case is actually now very likely going to be having some kind of determination from the U.S. Supreme Court?
Well, I'll tell you, Greg, it would be, heaven to hear that they actually put this injunction in place. I'm very hopeful. It surprises me that she's taken this case basically twice now. And when you read the ruling or the opinion and ruling from the federal appellate court, it's just so egregious. You go through it and it's like they literally are slapping the Supreme Court right in the face. So when we filed this, and there was first this little issue about the gatekeeper and getting it into the Supreme Court, but it was denied in the appellate court, so we were able to go ahead and file it. And I'm very hopeful it can make a huge change. Right now, we are really, living on life support pretty much, and we need some relief so that we can at least try to rebuild. It may take, many, many years to get back to where law weapons was. And I don't know that we actually can get that far again, the time left and the amount of damage that's been caused so far. But, I'd love nothing more but than to be able to at least get back to work, help the people of Illinois, fight their rights, keep their rights from the state and the city of Naperville, and just do whatever we can as good citizens to help everybody. And that's really why we started this whole thing. We could have packed up and moved away, but we said let's stand and fight. Let's fight for everybody who really doesn't know what to do. Since we're in the industry, it's not only affecting us, it's affecting everybody. We said we have the best chance of trying to make this happen. And without the National Gun Rights Foundation, we would have gotten nowhere. They have been a tremendous help. I think every person out there needs to be a member of their organization. If you're not, you're really missing out. They are advocates, and they're in the forefront of this. And I have never had a better relationship with any of the other gun advocates out there, the different companies. And so I recommend it. I tell everybody, please go over there. First of all, send an email to Hannah and say hi, and then sign up and become a member of National Gun Rights and help us all fight this. And we're fighting for you. So hang in there, and it would be a great thing for this to happen. And I think it will. I think she's gonna rule in our favor on this one.
Well, and Hannah, if you could just here briefly, I want you to also give the information where people can get more info about the National Association for Gun Rights. But to what Robert was saying irreparable harm. I mean, that sounds like what he's experiencing right now. Well, how significant is that in the request for an emergency injunction?
Well, we think it's hugely significant. The response that Naperville has always resorted to is if we win the case, we can always ask for damages. But, damages after the fact aren't going to make up for the fact of all the loss, the fact that he's essentially more or less lost his business and will have to rebuild. But even that, from a legal perspective, is not as significant as the fact that any day that you're trampling on a constitutional right, there is no remedy for that. And Robert's rights have been trampled on. The rights of law-abiding citizens of Illinois have been trampled on. That is not okay. There is no remedy for that. And we hope that the Supreme Court will recognize the gravity of this situation.
And if you could also, again, just tell us, where people can find more information about your organization, and if they feel they can support you guys.
Absolutely. So you can find more information about our organization at gunrights.org. You can find more information about the legal side at gunrightsfoundation.org. So either of those sites will get you where you need to go. We would love to have the support of anybody who is interested in fighting for the Second Amendment.
Again, Hannah Hill, Robert Beavis, thank you both for taking time with me this morning, and we'll be talking again soon because December 6th is just around the corner, so we'll all be anxiously watching to see what the state's reply is going to be. Take care, guys. I appreciate it.
Thanks so much, Greg.
Thank you, Greg. Take
All
care,
right,
Greg.
you
Bye-bye.
too. It is Bishop on Air. Greatly appreciate them taking the time with us as we broadcast here. And, of course, if you missed any of that coming in live, you can rewind or you can find the segment whenever it goes live here soon. But we're going to connect again with Robert Beavis next week to talk more about the law bolt and it really delves a little bit deeper into that. Also next week, we've got to start going through the frequently asked questions. I'm getting questions that I don't know the answer to. People are emailing me about, well, this January 1st deadline's around the corner. Can I move my firearm out of the state and be okay? Or do I have to file an affidavit regardless? Or what's going on there? A lot of Q&A and the frequently asked questions getting changed. But we'll obviously be unpacking a lot of that and more. Have yourselves a great weekend. Don't forget to support Bishop on Air. You could do so by going below on the YouTube feed and getting yourself a coffee mug, a t-shirt, a hat. I had a whole bunch of stuff I was going to flash, but left it in the other room. What am I going to do? But we'll be, showing off some of that stuff. But you can also just tell your friends about the program, all right? Have yourself a great weekend. We'll be back here Monday morning. Same Bishop on Air channel, same Bishop on Air time. And, boy, we got a lot to cover, all right? December 6th, state has to respond to the Naperville case in the U.S. Supreme Court. December 12th, you've got the Southern District of Illinois in the hearing with the federal firearms licensees trying to block the January 1st deadline. December 14th, state has to respond to the Dan Calkins case to the U.S. Supreme Court. And we'll watch all the pieces drop into place each and every weekday morning right here, all right? We'll see you guys soon. Have a good weekend.